This is a trial plan. This is a system that Brian and I use for pretty much every single case that we have. I've used it since day one as a baby attorney. And we can use it for any subject matter, IP, labor and employment, product liability, and we suggest that you use it really for any case that you have. It's a way to map out a case from the moment that you pick one up, even technically before a lawsuit is filed, and then it can take you all the way through appeal. Now, ideally, outside counsel will be managing this type of document to handle all of the information that comes in through the life of a case, whether it's case law, the jury questions, and the evidence, and so on. Now, the old saying is that you don't file a petition or an answer until you have outlined your jury charge, but the new saying is don't file a petition or answer until you've outlined your appeal. We all know that a judgment is only useful if you can hold on to it during an appeal or through an appeal. You certainly don't want to be poured out. But if there are gaping holes in your case, how are you going to know? How can you create risk to get to a settlement before an appellate opinion comes down, let alone survive the appeal? You do something like a trial plan. The trial plan allows you to see where the holes are in your case so that you can plug it up before it's too late, or in some situations, cut your losses early. All right, we all love Kermit, he's great, but in this situation, we don't want to be like him. Let's imagine for a moment that we're in Dallas, we're trying to get to Alaska. We've never been to Alaska before, we don't have a map. Some of us may get there, some of us may not. It is almost 100% a certainty that we're going to spend extra money on food and gas because we've taken wrong turns and we've spent extra days on the road. That's the same thing as handling a case without having a written plan. We don't want to be like Kermit trying to figure out if we're even looking at the roadmap the right way. A trial plan is that roadmap. It is like a GPS. You can know where you are at any point in time in a case, and you can know how to get to your destination. But it also helps with roadblocks. Let's say that a cause of action has failed, or there's some evidence that you think you really need, and you can see that it's inadmissible. Well, when you have this written down into a trial plan, you can see that early on and address it, or get around that roadblock. When creating the trial plan, something that is imperative is having a conversation between in-house and outside counsel about what the goals are. And I know that sounds intuitive, and of course we do that, but oftentimes lawyers can pick up cases and immediately think, especially litigators, we're competitive, we want to win. Well, what is winning? Does that mean maybe your organization has a low tolerance for trial because you have a high volume of litigation and you want to dispose of it early? Maybe you want to make an example of plaintiff, and so you want to be aggressive with motion practice and discovery. Or maybe it's a bet the business type of litigation and it's all hands on deck. We are preparing for a long day in trial. It's necessary to have that conversation early on so that you can figure out what the trial plan, what the trial strategy should look like. The other thing to note about the trial plan is that it's dynamic. This is going to change over time. It's not going to be static. Typically, the legal section, which I'll cover in a few minutes, typically the legal section will be static, but you still want to keep an eye on any developing law. But as the evidence rolls in, you should constantly be updating this trial plan as the case progresses. And then something else that I mentioned briefly is that the trial plan can, and to the extent possible, should be used before a petition or an answer is filed. Whether it's trying to determine if you should bring a case or just figuring out the strategy early on about how you want to respond or answer a certain demand or complaint. Okay, well, my nice animations didn't work here, but that's okay. So I'm just going to go through the trial plan. If you look at the leftmost column, you'll see cause of action. And typically, a trial plan will have 6 different columns. Sometimes it will have 7, and we'll discuss the difference. But the first column is cause of action. And you notice that there are 2 different colors. There's a blue chart and an orange chart, or a gold chart, excuse me. The reason they're in 2 different colors is because you want to make sure that one cause of action is its own chart. Sometimes these trial plans can get to be upwards of 300 pages, the largest size page that we can, or paper that we can find. And if you are looking at it on a computer, you want to easily be able to tell what cause of action you're referring to. The whole point of a trial plan is to be efficient and quick. At any point in time, you have whatever information you need. Then you have the elements. You're going to pull the elements from case law, statutes, regulations. You want to make sure to drill down into sub-elements or sub-factors. You'll have the law that corresponds to the elements, the evidence that corresponds to the elements, and then the predicates. One note about the elements is that you want to make sure each element has its own row. And then the predicates, which Brian will get into, the predicates are the hurdles to admissibility at the time of trial. The last thing that we like to do is include the jury questions and instructions and definitions, and we draft those based on the elements, the law, and the evidence, where those three pieces of the trial plan combine. So something to emphasize here is that the organization is absolutely critical. Again, these trial plans can get to be very large, so you want to make sure early on that you are managing the organization. If you see these arrows are pointing right and down, across each row you have A, and then the next row is B, and the next row is C, because we want to emphasize that each element corresponds to its specific law and its specific evidence and its specific predicates. One thing that I wanted to give you an example of, let's say there are 5 causes of action in your lawsuit. Each cause of action on average has 6 elements, and then each element has 10 pieces of evidence, and then each piece of evidence has 2 predicates, and then the predicates may have their own sub-elements or sub-factors. You're talking about well over 2,400 pieces of data. How do you maintain that information unless you have something like a trial plan to navigate through the case? Okay, so let's talk about drafting the legal section. Something that we like to do, I give so much credit to labor and employment attorneys out there wherever you are, because the intentional effort that an L&E employee or attorney gives toward the beginning of a lawsuit is admirable. The client interviews, the interviews with friendly witnesses, obtaining documents early on, that is something that we strongly encourage. The law of averages suggests that you as a client may have 50 to 75% of the information, the documents that is necessary for a case. So we as outside counsel should have that information before we even get to the discovery phase. And where are you going to put that information? In a trial plan. Go ahead and Bates label it early on, even if you don't produce it, so that you can manage it more efficiently. So once we do the client discovery, outside counsel should come up with keywords to do some case law research. Now, this is the issue spotting phase. Of course, it may be relatively easy to figure out that this issue involves breach of fiduciary duty. But if you don't do the case law research early on, then you may find yourself missing critical information later. As an example, there are some jurisdictions that say that a breach of fiduciary duty claim requires experts on damages. Not every jurisdiction says that. And if you get to the point of summary judgment, discovery has closed, you didn't have an expert on damages, now you can't proceed with that claim. Something else actually that was interesting, I had an associate do some research on, gosh, what was it? False association regarding a woman's likeness. And she was doing the research and she came up with invasion of privacy by misappropriation, which in full candor I hadn't yet seen. And again, that just goes to emphasize the reason why research is so helpful early on in a case to populate your trial plan. Okay, so we have the cause of action. You see here, breach of fiduciary duty, breach of contract. And then you move on to the elements. And again, each element is going to have its own row, and you're going to pull that from your research. Of course, you can start with O'Connor's and Dorsanios or any other secondary source, but just make sure to do your research because those books can be outdated in relation to the live law that's out there. One thing that we like to encourage is to think of a trial plan as a checklist, or think of it like a no evidence summary judgment motion. As a plaintiff, you have to show 100%, like you have to get every single element right or you're gonna fail on a claim. Before a defendant, you only have to disprove one of the elements. And what's really cool about the trial plan is that it's a visual tool. So you can see at one time, oh, this whole box of evidence is empty. We need to find something quick, or that's where we attack our opponent. Let's see. I already chatted about the sub-elements, but I do want to make, I want to emphasize, so if we think about exemplary damages, fraud, gross negligence, or malice, but if we only list out those elements, then we're missing key factors that we have to present to our finder of fact about whether we should be awarded exemplary damages. And in that context, there are more than 30 sub-elements at issue. Again, if we don't house that in a trial plan, how are you going to properly capture at the time of trial where it may be too late? Something else that I do want to point out that I may have missed, and excuse me if I'm repeating myself here, but with the causes of action, let's say you have, defamation, and defamation's in blue, we want to make sure that the affirmative defenses are also in blue. They correspond to the direct claim they're responding to. So you may have truth as a defense to defamation, and it would be in blue as well, because again, if this trial plan gets to be 300 pages, it's a little difficult when you have to flip back and forth between an affirmative defense section that's floating at the end and then find the corresponding cause of action. All right, let's move on to the law. Now, typically you'll already start filling in the law because you have done your research on the elements. It's important to find 3 different types of law. You want to have the law that lists, so if you look at breach of fiduciary duty, you have just one quote that lists all the different elements. You also want to have law that explains. There may be some other case that says, oh, fiduciary relationship exists when, so on and so forth. And then you also want to have law that is analogous, factually analogous to your case. And one of the reasons that this is useful, even if you don't get to the point where you fill out the evidence and the rest of the trial plan, which hopefully you do, this is really invaluable when it comes time for motion practice, for summary judgment, for directed verdict. You already have the information available, ready at your fingertips, and you don't have to scramble at the end of the day or right before on the eve of filing. What else is neat is that this part of the trial plan is a template. So you do this once, you save it in a bank, a repository that you have, and then you can always refer back to this template. Now, of course, you want to update it over time, but when you have the next breach of fiduciary duty case, you can refer back to this chart without having to recreate the information over and over again. And then one other note, and I'm going to turn it over to Brian. You see here the blue underline on these 2 charts because we hyperlink. You can hyperlink to Westlaw and Lexis or case text, however, or you can save the document locally. And again, the whole point of this trial plan is just to make it efficient and easy and at your fingertips. All right.
Thanks. Thank you, Christina. Excuse me. So once we've got, that's loud. Once we've got the elements, once we've got the law, then we want to start getting into the evidence. And this is where the process really starts coming together. And the first thing that we do with respect to the evidence is we create issue codes. And these are numbers that are tied directly to the causes of action and each of the elements, each of the sub-elements. If there's 10 factors that are considered, each of those are going to have their own specific number. Here we've got breach of fiduciary duties, 1.0 fiduciary relationship breach. You may have 1.2.1 that is all sorts of other specific breaches that are potentially going to be in play. We'd have 1.4 that would be damages on this particular chart. But the issue coding is absolutely critical for purposes of organizing all of this. If you don't have the issue codes, then you can't tie the evidence to the law, the cause of action. You can't get it into the trial plan. Here's an example, like with causation, you've got sub elements here, and you have to be precise. If you look at exemplary damages, for example, there are arguably 30 plus elements or sub elements or factors that you have to take into account. And that's a lot of different codes, but it's important to have them all there because, especially if you're on the plaintiff's side, you have to establish all of those if you're really going to be entitled to exemplary damages, recover it, and then actually keep it on appeal. It's also helpful with respect to the issue codes at times to tie them to specific facts of the case that you know may be in play. So you've got a breach of contract case, and the contract is 1.1, valid and enforceable contract. 1.2 is breach. Well, maybe 1.2.1 is breach for failing to timely pay an invoice. 1.2.2, is breach for failing to timely complete the project or something like that. So you can weave the facts as you know them into the issue codes, but at the end of the day, you do want to try and make it as similar and consistent to the cause of action, to the law, and each element and factor. This is an example of issue codes. It's a separate, Word document that basically you just start, playing with the numbers and you go through each cause of action. You're going to do this with affirmative defenses as well. And you're just breaking it down. You're breaking it down consistent with what you've already done in the trial plan, with the cause of action, with the elements, with the law, and trying to get as specific as possible. You're going to do this for every single cause of action. You're going to do it for every single defense, and you're going to do it for potential claims. If you think that there's a claim, or if you think that there's an affirmative defense that you may end up wanting to assert down the road, we put it in there on the front end because cases evolve, as we all know. And the last thing you want to do is be in the middle of litigation after years where there's been tens of thousands of documents that have been produced, and then you're trying to recreate it, figure out what evidence we have and where you want to do it along the way. And that'll avoid, duplication. It'll save you, money in the long run too if you decide. And you can monitor the potential claims as they go along. Do we have a good faith basis for bringing this lawsuit or bringing this claim? What do we need? What are our holes? And you want to get as detailed as possible. So once you have done the issue codes, then this is where it starts to kind of get fun because you want to take the issue codes and you want to apply it to the evidence. And you want to tag the evidence with the issue codes. And the way that we do this is we've got various programs. We use Opus at GT. And you go into Opus and you plug in all of the issue codes that we just looked at, from 1 to whatever it may be. And then you load in the deposition transcripts. You load in the documents to the program. And as you go through and you're reading the deposition testimony, if there's a Q&A that is relevant and needs to be tagged for a potential issue code, you are going to tag it as such. And a lot of times, there could be Q&A that is 5 different issue codes because they relate to one another. But we go into this program called Opus. There's other ones like Summation, and basically tag all of our evidence, link it up to the issue codes, and order to ultimately get into the trial plan. One important thing when we're doing this process, though, is this is not just the good evidence. It's the good and the bad and the ugly. Whatever we see, if it's related to a specific element, a specific factor, it needs to be coded. Because this whole tool it's a case evaluation tool. It's a lot of different things, and it has a lot of different benefits, and we'll talk about that a little bit at the end. But you've got to put the good, bad, and the ugly. You've got to code it all because otherwise it's not going to be a reliable tool for you and for your outside counsel and in terms of prevailing on the case. One other important thing on the issue coding of the evidence is it's important to do it as the case progresses. A lot of times, if you're on the plaintiff's side, before you even bring a lawsuit, you may have 30, 40, 50% of the evidence, maybe more, that you already need to prevail on this cause of action. There's no reason why you can't prepare a trial plan, get all of this done, issue code that evidence, and get it into a trial plan and figure out, how far along are we? What do we need? Where are we going with this? What are the claims that we can bring? On the defense side, if you get sued, immediately, you're going to start doing an investigation. What happened here? What are these claims? What are our defenses? What documents do we need to collect internally? Start pulling all that information together. You can immediately start issue coding that evidence and move it into the trial plan. And you want to do that as early as possible because, as you can see from this, it's an evolving product. It's changing. But the earlier you start doing this, the better it is. So once you have the evidence issue coded, you have the ability to filter it out in these various programs. So in Opus, if I want to pull all of the causation evidence with respect to my breach of fiduciary duty claim, I can go into Opus and I can generate a report from 1.3. And essentially what that's going to do is it's going to put together, compile all of the deposition testimony that we have coded into a nice little report. I'll show you an example in a second. It's going to tell me all of the documents and the portions of the documents that we have been coded, that have been coded within the program, and that relate to each specific issue code. Here's an example of an Opus report for a particular. We've obviously changed names and all that good stuff. But this is what it would look like. So, if I'm running a report for 2.2 here, there are, two different portions of Alex Lopez's deposition testimony that were tagged for defendant knew of a fiduciary relationship. You can see at the top, that testimony had 2 tags. Again, that's very common that you're going to see stuff that's going to be tagged, with numerous different codes. So once you have done the issue codes, you've gone in, you're reviewing your evidence, you're coding your evidence, you're tagging it, then you've got to take the next step to get it into the trial plan. And the way that we do that, we looked at the master, but the trial plan has an evidence column, right? And you've got each row is matched up to each element and each sub-element and each factor. And if you go into the evidence section of each cell, that's going to be where you dump all of the evidence that is generated for that particular issue code. So like for here, and normally I would do like right by the A 1.1 because that's going to be all of the evidence, good, bad, and ugly, relating to whether there's a fiduciary relationship in my case. And one of the things that we do is, we put it in here, we hyperlink it, and we're hyperlinking it either to the actual document or we're hyperlinking it to the Opus issue coded report. So we just looked at, this report right here. This is probably a 2.2 report, right? And so if I was to click on Mason Depp, that testimony, and it's 1.1 here, but that would take me to the Opus report and show me where the actual testimony is. And it's important when we do this to not just cite to Mason deposition, page and line, right? Because if you're just putting that in there, it's not going to tell you anything. It's interesting, okay, there's something important, but I don't know why it's important, I don't know why it's good, I don't know why it's bad. So when we go in, to the extent we can, we're summarizing what the testimony is. If you have a personal injury case, and we've all had this happen, you have a plaintiff that gets injured, I can't walk anymore. And then, they file a lawsuit claiming that, and somebody gets on Facebook when they're doing due diligence on the plaintiff, and a month before they filed the lawsuit, there's a video of them out dancing, right? So you're pulling that down, you're going to tag that as damages in your trial plan, and you're going to hyperlink that video under the evidence, under the damages section, right? But you're not just going to plug the video in. You're going to say, video of plaintiff dancing 1 month before this lawsuit was filed. A lot of times on the evidence section, if there's a key if there's a key quote or anything like that, we'll copy and paste it in there. But a lot of times you may have issue codes of testimony that's a page long, and you're not gonna copy and paste everything in there. So we get the evidence in. We've talked about the elements. We've got that in. We've got the law. We've now created the issue codes. Excuse me. And we've issue coded the evidence, and we've now got it into to the trial plan. And this is how it looks. A lot of times on the evidence, again, you want to put good and bad evidence, good or unfavorable evidence in there. We may make some sort of indication that it's red or but C or so. If there usually you want to put favorable evidence in there, but if there is something that is not favorable, it needs to be in there and it needs to be identified as such. So once you've got the evidence in there, you've got to figure out how are we going to get this evidence in at trial. A lot of times you go through the discovery process, you're getting all this great testimony, you're collecting documents, but people are not thinking about how are we going to get this in at trial. And you have to be thinking about that, because if you're not, and you get caught flat-footed at trial, and you're not getting your evidence that you had in your trial plan, and it can obviously kill your case. Sources of examples of predicate, rules of evidence, rules of procedure, local rules, statutes. Those are the kinds of predicates that we're talking about. Here's some examples here. To the extent that there's any kind of issue with the admissibility of a piece of evidence, you want to be sure that it is properly, I don't want to say briefed, but it's identified and pointed out in the predicate section. A lot of these predicates may have sub-elements of their own, and you've got to figure out how are we going to satisfy those in order to get that evidence in at trial. It doesn't matter how great something is, how great a document is, how great a witness statement is, if you don't figure out how to get it in. And you want to do this as early on as you can, because if there's going to be problems with admissibility at trial down the road, you want to figure out during the discovery process, what are other ways I can get this same information, because we need it for our case. You don't want to get on the eve of trial and be figuring out, how are we going to get this in? Oh, I didn't think that the plaintiff was going to object to that document. Crap, what are we going to do now? We haven't thought about that. So it's imperative when you're going through this process to go through. We go through each piece of evidence, and here you can see, you've got A1, that's the piece of evidence, and then A1 on the predicate. So you got to break it up and go through each individual one. Yes, it can be tedious. Yes, it makes this thing longer. There is a lot of duplication, but it's critical. Okay, so once we've got our predicates, then we get into the jury questions and proof. And at the end of the day, this is where the legal section of the trial plan and the evidence section come together. The jury question combines an element that must be proven or disproven with the particular facts of your case that are relevant to the claim. And so here we've got existence of a fiduciary relationship is the element. And when we're going through and writing this out, we want to write it in a way that is favorable to what we have to prove or disprove at trial. So in this particular case, we're going to affirmatively state that a fiduciary relationship existed between Chris Mason and Carroll Incorporated. Sometimes the corresponding element or sub-element is expressed in a jury instruction or a definition. If you've got a legal malpractice case, and one of the issues is, was there an attorney-client relationship? The definition of attorney-client relationship is going to be provided by the court, but that's still something you want to have in here. You want to have that definition in here, and you want to be sure that you have the evidence and the law to satisfy that definition. Sometimes the existence of an element will be a question of law for the court, whether an agreement constitutes a contract. A lot of times can be a question of law for the court. So you would put that in here, but you would obviously indicate that it's something that the court is ultimately going to decide. The proof, the jury question, again, will correspond to the evidence section, right? So you've got fiduciary relationship existed between Chris Mason and Carroll Incorporated here. And if you look immediately to the right, that should be the evidence that supports that proposition, just like it is here. This is another thing that it is so critical to do as early on in the case as you can. You can go to the PJC right off the bat. You can figure out what is the jury going to be asked, what are the definitions, and you want to pull that information and you want to understand it as early as possible. It shapes discovery, it shapes settlement, it shapes written discovery, it shapes depositions, how you ask your questions, what questions you ask in depositions. And so it's critical to get this information as quickly as possible. So once you've got all that, this is an example of kind of what a finished product would look like with respect to a breach of fiduciary duty claim. You've got, again, the cause of action on the far left. You've got the elements, the law, the jury question, the proof. What are we going to have to prove or disprove at trial? What is all the evidence that supports or doesn't support that proof? And how are we going to get it in at trial, or how are we going to keep it out? Now, we've talked about what a trial plan is, but now let's talk about some of the benefits to why we go through this process and why we create these massive binders that have all sorts of information in them.
Well, I am sure we have already convinced you that this will totally change your life, but in the event that we have not yet, yes, we will go through these benefits. I will start with cost. There is, of course, a front-loaded cost here because your trial team, your outside counsel will be doing the work on the front end, the research, the client discovery, talking to friendly witnesses, obtaining those documents. But there's a cost savings on the tail end. On the one hand, it's a single repository of all the information for your case instead of outside counsel having a number of notes and documents in different places and no way to tie them all together. I will give you an example. Let's say that your outside counsel takes a deposition and gets the transcript back and doesn't do anything with it at the time. There's no issue coding. There are no summaries that are put into the evidence section of the trial plan. And then it's time for summary judgment. So outside counsel now has to review that deposition transcript. Maybe it's been 3 months, maybe it's been a whole year. And they're reviewing this transcript as if it's new. And so they review it in time, do a good job for the summary judgment, but the case proceeds to trial. Now outside counsel has to review that deposition again to prepare for cross-examination. Well, when you have a trial plan, you can avoid 1 to 2 of those reviews. And let's make this a little more tangible. Let's say that your outside counsel is charging $800 an hour. It takes 4 to 8 hours on average to review a deposition transcript, depending on how long it is. So that's on the high end of that estimation, $6,400 to review a deposition transcript one time. Well, I said that they're reviewing it for the MSJ and cross-examination, so now you're looking at least $12,000, well, on the high end, roughly $12,000, and that's just for one deposition. But you probably have 5, 10, 30 depositions in a case. So again, this can get to be where you're saving upwards of $100,000 by having a trial management system like the trial plan. Another way that you can save costs, as I mentioned before, is by using these as templates. Once you create the cause of action element in law section, then hold that as a blank template for your next cases. Let's say you have your in-house counsel, you have a high volume of product liability cases, and it's the same types of claims that you see time and again. Well, once you have this template, all you have to do every time you get another case is just plug in the unique facts and go on from there. So you're cutting down I don't know, a third, half of your time. Let's move on to talking about organization. Yes, it is a single repository, but it's also a great way to maintain institutional knowledge, and that's both for outside counsel and in-house counsel. I'll give another example. Dear Brian here was left to his lonesome. We were working on a massive piece of litigation a couple of years ago, and an associate left at the same time that I was on maternity leave. And the three of us were the day-to-day team on this case. Can you imagine what it would have been like had he had to deal with all of that and there was no single repository where we left all of our knowledge on the page when we were out of the office? So sometimes outside counsel or in-house counsel may leave the firm or the organization temporarily. Sometimes it's permanent. And you have to make sure that the team that is left behind or the team that comes into the fold or even new team members that are added, that they have the knowledge to be able to finish out the litigation. Something else that the trial plan is really useful for in-house counsel is to monitor the case and to understand what's happening. It's really great to be able to share this massive document with in-house counsel so that you can know what we know at the same time that we know it. Now, obviously, there's some progress that we'll still have to update you on, whether through calls or memos or what have you, but it's a really, really great tool that you can assess the case just as we're assessing it. And then I'm sure that all of us here have to report to somebody, whether it's the general counsel or a CEO or the board. So it's great that you as in-house counsel can have a document like this to be able to report up, this is what our outside counsel, this is what they're doing, this is how they're using the information, this is how they're using our resources to build up our case. For procedural hurdles, in addition to needing to satisfy the elements and needing to satisfy the predicates, there are some procedural hurdles beyond that. Let's talk about standing or capacity. I had an issue several years ago where we were brought into a case on the eve of trial, and unfortunately, standing had not been addressed before said eve of trial, and so we had to scramble to figure that out last minute. Now, had we had the benefit of a trial plan early on, that's something that I think we would have caught sooner. Or another example is there's some key evidence in the case from a party that is now deceased. So we know that there's a dead man's rule issue. How do we get around it? Are we able to get it in? Do we need to get some other evidence? Do we need some corroborating evidence to be able to get that testimony in? Another really great use of the trial plan is expert issues, addressing expert issues. So I think I mentioned earlier on how in some jurisdictions breach of fiduciary duty requires a damages expert, but if you haven't done a trial plan, then you wouldn't, well, a trial plan or some other system, I will give credit to other systems out there, but if you haven't done that research early on and you haven't kept it in a single repository that you can refer to throughout the life of the case, then you may miss some of these really big issues that can be detrimental to your case.
Case evaluation is obviously a huge part of this process because throughout the life of the case, at any point in time, you can sit down and evaluate what you do have, what you don't have. If it's a lifetime product, it's obviously something that is a work in progress throughout, but if you've got, bet the company litigation, being able to sit down and with this and go through and figure out what are our strengths and our weaknesses, where are we vulnerable, what evidence do we have, how are we defeating this cause of action, it just makes everything much more tangible, much more real, seeing it. This is what's going to be, and not only through the process, through the discovery process and through trial, but thinking about appeals too. You roll the dice, you go to trial, you have the benefit of knowing that you've looked at all the law, you've looked at all of the evidence. This is how we're going to hold our judgment on appeal, no matter how far it goes. So it allows you to evaluate the case and the strengths and weaknesses throughout the entire process. And I know, not everybody has time to sit through, and you're not going to go through the entirety of a document like this. You're not going to click on all the evidence. You're not going to read through it all. But a lot of times you may be asked, by whether it's the general counsel or somebody else, hey, there's this one issue I'm really struggling with. Like, what are the damages? How are we going to defeat this? Okay, well, let's go look at the trial plan. Let's go look at what we have and what we've already done. Let's go figure out the law. Let's go figure out the evidence. Let's go figure out what else we got to get to where we want to go. Hand in hand with case evaluation is settlement. And, it kind of speaks for itself, but if you're on the defense side and, you're able to sit down and that you have a piece of evidence that you've identified that just completely blows up an element of plaintiff's cause of action, you're going to be more empowered to fight and want to stick it out and file summary judgment and take the case to trial. On the flip side, if you're sitting there and you're seeing that, we may have issues here. The plaintiff, we're identifying all of this evidence that has come out, and we've got real problems. We may need to get out of this thing. It's not going to be worth our time and money to keep fighting it. It is also a very beneficial tool for mediation. I've sat in opening sessions from opposing counsel and clients, and being able to sit there and show them, look, we've already beat you, and you don't even know it. I had 3 people when I was dragging this thing upstairs be like, "What in the world is that thing?" So it's something that catches people's eye, but it's a tool that you can use. You're sitting in a mediation, and you hear from the other side, "Oh, they can't prove that. We already have evidence of that." Okay, no, you're wrong. Let's sit down and let me show you why we're going to prove what we need to prove, why they can't establish this. And maybe you're sitting there showing it to the mediator. So for mediation purposes, and then, all the way through trial, you're on the eve of trial. Are we really going to go try this case? You got settlement discussions that are happening in a lot of litigation right before trial. There's a lot of posturing going on, but you want to be able to go back and see, look, if we go forward on this thing, do we feel good about this? Do we have any holes in our case? And if we get all the evidence in that we've identified in this big document, are we going to be in good shape? Discovery is another incredibly important benefit to this document. You need to have a plan going into discovery, both written discovery and depositions. Before you start drafting written discovery, you should have the elements lined out, the law. You need to know what you're asking for and why you're asking it. And if you're not, you're just kind of shooting in the dark. And you have to have that plan, and having this tool makes you sit down and figure out, what am I asking? Why am I asking it? Younger associates, it also helps them kind of figure out, how do all the puzzle pieces fit together in terms of what we're asking, what we're not asking. Preparing for depositions, you're putting together a deposition outline. You need to be looking at what the law is. You may be asking questions directly from the case law. I've been in depositions before where I sit and ask the plaintiff a question that is based on the law, and they're half paying attention, give me what I need, and they don't know that they just blew up their entire case. It's over because of the way that the question was formatted and articulated, and being consistent with the law and what has to be proven or what has to be disproven. And it allows you to be organized. You know what you need in terms of discovery. You're able to see, what else do we need. If you've got a few months left in discovery, you can sit down, man, we need to prove this element for this affirmative defense. We don't have, what else can we do in terms of depositions or written discovery to be sure that we are rock solid on that waiver affirmative defense. And it's something that you can use for that. The other thing, motion practice. We all hate dealing with discovery motions to compel. I'm sure you all hate paying for all of that. But when you've tailored your discovery to the trial plan, getting past relevance objections and stuff like that is easy, because hey, I asked for this discovery for this particular reason, because it's our burden to prove this, because their plaintiff is alleging this and we have to disprove this, and you already have a plan. All right. What else?
Summary judgment.
Oh, summary judgment.
Which is more
Yeah, on the defense side, I think the best tool that you can always have on the defense side is a no evidence summary judgment. And if you're on the plaintiff side and you have a trial plan, responding to a no evidence summary judgment should be a piece of cake. You already have the law. If you've put all the evidence in there, well, it should be a piece of cake if you actually have the evidence to support your claims, right? But you have everything in one place already. You've already done the hard work. If you're responding to traditional summary judgment, you're going through that practice, you should already have all of the relevant law brief. You should know those cases that are analogous and that are going to be here. You should know the evidence that is going to create that fact issue for you. It should all be in there. So you're saving time, you're saving money. You already have a lot of this stuff. And again, you can visibly see the holes in your case and your opponent's case.
So moving on to the last two benefits here that we at least have listed, I'm sure there are more. One that Brian mentioned just a minute ago is trial. Obviously, one of the benefits of the trial plan is preparing for a trial. So figuring out what evidence you need to get in, what are the admissibility hurdles. It'll help you draft your exhibit list, your witness list, and your motions in limine. I'll give some examples. So because we've filled out our trial plan and we know what evidence we need to come in, well, that is your exhibit list. Because we filled out the predicate section, we include who are the sponsoring witnesses. That's your witness list. And then for motions in limine, again, these are going to be some of the issues, whether it's legal issues or other factual issues, some counter evidence that you flag that you want to keep out through a motion in limine. Something else it's useful for is directed verdict. Much like a summary judgment, you're monitoring during plaintiff's case in chief and you see whether they got the evidence in that they needed to get in. You're checking your trial plan, or maybe when you go home that night you refer back to it, and if you see that there are some holes in their evidence, then you can use the trial plan for directed verdict. And then the last piece is training. We refer to this also, how useful the trial plan is to just bring up more junior attorneys. Oftentimes junior attorneys, as I'm sure all of us remember, are task-based workers. And they don't always see, they are not always presented the opportunity to see the whole picture. A trial plan is a great way to get them, like bring them into the fold and get them involved from the ground up to understand what the case strategy is, not just what the claims we're bringing, but what are the hurdles. And then it's also a great training tool to teach them how to work up a case generally. So we ended with a few minutes to spare, and we will take questions if you guys have any, but generally, thank you.